Okay guys, in our last chapter regarding governor, we have discussed some points. Here I am again going to discuss some important points. Mind that I'll only point out on those lines or those words where there is a puzzling or where there is a chances of puzzling. Okay, rest you have to read the carefully every book. Now came to judicial power. The thing is that option 1 option 1 governor can appoint the judges of state high court. Governor can appoint judges of district court. Which of the following is right? The thing is that governor cannot appoint the judges of state high court. President appoint the judges of state high court, but consultation is necessary. President appoint the judges of state high court after consulting with the governor. In that way, governor can appoint the judges of district court. Okay, but governor cannot appoint the judges of district court on his own. In this case, he has to consult with the concerned high court. Mind the differences. Governor can appoint the judges of state high court. No, governor cannot appoint the judges of state high court, but president appoint the judges of state high court after consulting with the governor. Governor appoint the judges of district court. Yes, governor appoint the judges of district court. Another option, governor appoint the judges of district court on his own. No, governor cannot appoint the judges of district court on his own. This last part, on his own, is wrong, because governor can appoint the judges of district court only after consultation with the state high court. So these minute differences in words are very necessary while reading this. Mind them. Okay, there is a chances of missing marks in exam. Again, you see, all know that governor and president both enjoy suspensive veto. Governor and president both enjoy suspensive veto in case of ordinary bill. Now come to the money bill. In case of money bill, the differentiating words are withhold and return. Option 1, I am giving two options. Option 1, president can withhold his assent to money bill. Governor can withhold his assent to money bill. Whether these sentences are correct or wrong. While we read the money bill, then we psychologically what we think, that psychologically a notion, a thinking immediately come to our mind that president cannot withhold his assent, or governor cannot withhold his assent to money bill. But withhold is right. Withhold is right. President can withhold his assent to money bill, and governor can also withhold his assent to money bill in case of state legislature. But wrong word is return. See, option 1, president can return money bill to parliament. Governor can return money bill to state legislature. These sentences are wrong, because president and governor cannot return the money bill to concerned legislature or parliament. But president and governor both cannot, if they think, both cannot give their assent. There is a chances that if they are not agree, then they can simply say that we are not agree. They can withhold their assent to money bill, but they cannot return the money bill. Mind the differences, withhold and return. Don't be confused. Don't apply that the president and governor cannot return the money bill. That's why don't apply this thinking in case of withhold also. So president and governor cannot withhold also. Okay, but president and governor can withhold their assent in case of money bill, but the thing is that they cannot return the money bill. These things are important. But again, another thing, governor can reserve money bill for the consideration of the president. Governor cannot reserve the money bill for the consideration of the president. Which of the sentence is right? Yes, in case of state money bill in state legislature, or governor can reserve money bill also for the reconsideration of the president. Mind that governor cannot reserve a money bill of state legislature for the reconsideration of the president. It is wrong. Governor can reserve a money bill of state legislature for the reconsideration of the president. Okay, but when the bill will go to president, but here also in this case also president cannot return the money bill for the to state legislature. He can simply give his assent and he cannot he can withhold his assent. Mind that in any case, okay, you might sometimes you might find the sentence in a different way. President cannot generally withhold money. President generally cannot return a money bill in case of parliament. Number 2, president can return a money bill if the bill is reserved by the governor for him. In this case also president cannot return the money bill. The thing is that return, beside the word return and money bill, always put cross red mark. In no cases the money bill can be returned to any house, whether it is in state or whether it is in center. Okay, these are very important. Money bill no return, money bill withhold. Yes, mind these differences. Again, see, in case of ordinance making power, both are same. Ordinance making power of the governor and state, both are president, both are same. In which say president can make ordinance if any one of the house is not in session. In that way, a governor can also make ordinance if any of the house is not in session, if there is a state if there is a upper house, in state. Okay, if there is no upper house, then governor can make ordinance simply when there is no session of the state legislature. Okay, mind this thing. You might find question in exam hall. Ordinance can be issued by president and governor only when both the houses are not in session. No, not both the houses. The word only makes the sentence wrong. If any one of the houses is also not in session, then ordinance can be made, because generally a law is made by the agreement of both the houses, whether in state and whether is center. Okay, that is why whether he is governor or whether he is president, ordinance can be issued by only when any ordinance can be issued by if any one of the houses or if both the houses are not in session. But another thing is that whether the ordinance making power of the governor and president is discretionary power or not. No, never. Ordinance making power of the governor and president are not a discretionary power. In case of president, it is the ordinance is generally issued by the president only on the advice of Central Council of Ministers or Central Cabinet Ministers. In that way, in state also the governor can issue ordinance only on the advice of state ministers, state cabinet ministers headed by the chief minister. This ordinance making power is not a discretionary power, whether it is by president or whether it is by governor. Mind the differences. Then another thing is that option 1, president does not require any instruction for issuing ordinance. Governor needs instruction for issuing ordinances. Yes, both the president, generally there is no need of instruction for president while issuing ordinances, but in case of governor there are some instructions which are necessary while issuing ordinances. You will yourself will read these what are those conditions from laxmikant. I just mentioned it. Just mind the differences. There is no need of instruction for president while issuing ordinances, but in case of governor there are some instructions which sometimes required for the issuing ordinances by governor. Mind that. In that way, mind in case of governor also. While governor, in my last lecture regarding governor, I told you that while reserving a bill for the state for president, there are some rules or there are some conditions in some cases which governor has to follow while reserving the bill for a president. In that way, in case of issuing ordinances, not in any cases. Okay, mind the thing that not always. In some cases, okay, if you find a sentence in an extreme way that a governor always needs instructions for issuing ordinances, this is wrong. Always not. In some cases, Not always. In some cases, he needs instructions. In that way, while reserving any bill for president also, not in all cases. Okay, if you find a sentences that the governor always needs, there are some rules always which the governor has to follow while reserving any bill for the president. No, it is wrong. Not always or not at all not always or not at all extremes. Okay, in some cases only. Mind these things. In that way, while pardoning, in case of the president, the difference is that president can president has the pardoning power in case of court martial power. President has pardoning or mercy power in case of court martial, but governor has no power in case of pardoning of court martial. It is important. And another very minutely you have to notice that president can pardon a death sentence, but governor cannot pardon a death sentence. But what the governor can do, governor can remit the governor can make lessen the death sentence. Okay, if you are if anyone is convicted of death sentence, governor can suspend, remit or commute a death sentence. Governor can less the sentences in sentence, but governor cannot totally pardon the person. Pardon is different. Pardon means what? A person make a person totally free from his conviction. It cannot be done by the governor. It can be done by president only. If you are convicted of a murder, God forbid you are not. For example, if you are convicted of murder, you give a petition to president. President can make you free from your conviction, but governor cannot make you free from the conviction. But what the governor can do, at best governor can make you make the death sentence into life sentence. Mind these differences. Now I will we will discuss some objective type questions regarding governor. You view question 1. Find the incorrect one. Option 1. An acting president does not require to take oath. In the absence of Chief Justice of India, any judge of Supreme Court administer the oath of the office of the president. Who is of the following is right, or who is of the following is right? Both are wrong. Why? Because an acting president does not require to take oath. An acting president also needs oath. Okay, an acting president has to take oath before taking the responsibility of office. In that way, in the absence of Chief Justice of India, any judge of the Supreme Court, not, it is the senior most judge of the Supreme Court. Okay, number 2C, correct. Choose the correct. President cannot be impeached until the breaching of grounds is defined by the Constitution. This option is wrong. Why? Because the ground of impeachment is now defined in the Constitution. Now we're defined. A criminal proceeding cannot be issued to a serving president until giving notice before 2 months. It is also wrong, because a criminal proceeding can never be issued to a serving president. Okay, whether it is for his any act done under official capacity, or whether it is for any act done under personal capacity. Okay, then after C, president has the sole authority to decide the disqualification of members of parliament. No, it is also wrong, because he has not the sole authority. He has to consult with the consult with the election commission. Okay, after that only he can take any decision. Once issued, ordinance can be repealed by parliament only. No, it is also wrong, because ordinance can be repealed by president also. Okay, after that, see, though Indian president is not a part of parliament, but he is an integral member of it. No, president is not an integral member of parliament, but president is a part of parliament. Again, say, though Indian president does not have situational discretionary power, but he has some discretionary in ordinary bills. No, Indian president has situational discretionary power. Except situational discretionary power, Indian president has not any other discretionary power.